Welcome to today's session. We are going to learn about the insolvency resolution and liquidation. First, corporate insolvency resolution process. Corporate insolvency resolution process is a recovery mechanism for creditors. If a corporate becomes insolvent, a financial creditor, an operational creditor, or the corporate itself may initiate CIRP. Financial creditors could be any persons to whom a business debt is owed or a persons to whom such amount is legally assigned or transmitted, for example, banks or other financial institutions. Operational creditors could be any person to whom any operational debt is owed and includes any persons to whom such amount has been legally assigned or transferred for goods and services done by them. For example, vendors and suppliers, employees, government, etc. CIRP is initiated after making an application. CIRP it's a process through which it is determined whether the person who has defaulted is capable of repayment or not. If a person is not capable of repaying the debt, the company is restructured or liquidated. Following are the steps to be followed for resolution or liquidation of a corporate. First, applications to National Company Law Tribunal. A financial or operational creditor of the company or the company itself can apply to the National Company Law Tribunal. The application is made to admit that corporate debtors are into CIRP. Interim resolution professional and moratorium. When a corporate debtor is admitted into the CIRP, it suspends the board of directors. Also, the management is placed under the independent interim resolution professional. Further, for this point, won't the management cease to have any control over the company affairs till the end of the CIRP. Simultaneously, a moratorium becomes effective which prohibits first, continuation or initiation of any legal proceeding against the corporate debtor. Next, transfer of its assets, enforcement of any security interest, recovery of any property from it by an owner, suspension or termination of the supply of essential goods and services. The moratorium lasts till the corporate debtor is in the CIRP. However, the moratorium does not extend to key business contracts entered into by the corporate debtor. Next, verification and analysis of claims. In this stage, interim resolution professional will summon and verify the claims made the creditor and also classify them. After that, within 30 days of acceptance into CIRP, will form a committee of creditors (COC) which comprise of all the financial creditor of the corporate debtor. Appointment of resolution professional. Within 7 days of this forming of committee, the COC will have to either resolve to appoint the interim resolution professional as a resolution professional or to replace the interim resolution professional by another resolution professional. Next, approval of the resolution plan. The resolution plan for the revival of the company must be approved within 180 days of the commencement of CIRP by creditors. The National Company Law Tribunal can extend this period by another 90 days. Next, the liquidation process. For initiation of liquidation. When the adjudicating authority, that is AA, either does not receive the resolution plan under section 30 sub clause 6 of the code or the maximum period prescribed for the CIRP expires, or when AA rejects the resolution plan under section 31 of the code Liquidation may be initiated under Section 33 of this. Furthermore, any time before the resolution plan is adopted and the resolution professional inform AA of such decision, the COC may resolve to liquidate the corporate debtor, that is CD, under Section 33 of suppose June with at least 66% votes. In addition, if the CD violates any terms of an approved resolution plan, any person whose interest is harmed by the violation may ask for the CD to be liquidated. While passing the order of liquidation of CD, AA shall direct the issuance of a public announcement under Section 33(1) of the Code that the CD is in liquidation, as well as the requirement that such order be sent to the CD's registering authority, such as the Registrar of Companies in the case of corporation. Then moratorium. Moratorium also applies when a liquidation order is issued, as it does in the CIRP. No legal action or litigation shall be brought by or against the CD. However, with AA's permissions, the liquidator may file such procedure on CD's behalf. Next, liquidator and fees. AA must name as an insolvency professional, that is IP, as liquidator while passing the liquidation order. If an IP has already been appointed as a resolution professional for the CIRP, he may be retained or another IP may be appointed. Subject to this approval and independence, among other things, under Section 34, Clause 4 of the Code, there are provisions for his replacement in specific circumstances. In the event that the resolution plan is not approved, the fee payable will be determined by the COC under Regulation 39D of the Insolvency and Bankruptcy Board of India, Regulation 2016. Financial creditor must additionally advance funds for liquidation cost over liquid assets available, which will be repaid with interest from the liquidation process. Fees would be based on a percentage of realization and distribution to stakeholders in all other circumstances, as specified by the Insolvency and Bankruptcy Code of India, Regulation 2016. Power and duties of a liquidator. A liquidator is necessary to supervise the entire liquidation process from the liquidation order through the CD resolution. He must take possession of all assets, accurately analyze them, and dispose of them in a transparent manner while keeping the code objective in mind. In the meanwhile, he must keep and safeguard them. For consolidation, he must invite claims and verify them. He can then accept or reject the claim. In the name and on behalf of the CD, he must defend any litigation, prosecution, or other legal processes, civil or criminal. Within 14 days of receiving the liquidator's decision accepting or rejecting the claims, a creditor may file an appeal with the AA. In carrying out his duty, obligations, and responsibilities, the liquidator has the authority to seek expert aid from anybody or designate any professional. Furthermore, AA's directions can be asked if any clarification is required. Next, liquidation state. In relation to the CD, all the CD's assets from an state of assets known as the liquidation state. The liquidator acts as a fiduciary for all creditors, holding the liquidation state in trust for them. CD's estate includes not only assets that he owns and controls, but also those that he does not control. Assets listed in accounting books or with information utility should be tracked and managed. Movable and immovable assets, as well as securities and shares held in subsidiaries and joint venture, fall under this category. Intellectual property and other intangible assets are also covered. Assets in the custody of a third party, such as those received in bailment, and all monies payable to any laborer or employee from the Provident Fund, Pension Fund, or Gratuity Fund are not included. Next, avoidable transaction. Preferential, undervalued, fraudulent, and extortionate transactions. Laws apply to liquidation proceedings in the same way they apply to the corporate insolvency resolution procedure. For connected parties, the relevant back period is 2 years prior to the insolvency commencement date, and for others, it is 1 year prior to the insolvency commencement date. AA may issue an order restoring the property or consideration in lieu thereof given in such transaction to CD based on a application from the liquidator. Transactions that are undervalued or unreasonable could be voided. Next, distribution of assets. Section 53 of the Code, sometimes known as the waterfall system, governs the distribution of CD assets in liquidation. The following is a priority order for the distribution of proceeds from the liquidation assets. Costs of liquidation have been paid in full. This comprise the liquidator fees as well as expenditure for retaining advisors, protecting assets, maintaining the firm, and interest on interim financing, among other things. Debts of the secured creditors who choose to renounce security and dues of the workman for the 24 months immediately preceding the start of the liquidation will be treated similarly. It should be noted that a secured creditor has the choice of asserting his security or allowing the liquidator to realize or disburse his security via this procedure. Next, wages and unpaid dues owed to employees other than workers for the 12 months prior to the state of the liquidation. Unsecured creditors are due financial debt. The following dues shall be distributed equally amongst the following: debts owed to a secured creditor for any amount unpaid following the enforcement of a security, interest for the period of 2 years proceedings the liquidation commencement date, debt owed to the central government and the state government as well as other government dues for the period of 2 years preceding the liquidation's commencement date. Any other debts and dues, preference shareholders if any, equity shareholders or partners as the case may be in the end. Next, dissolution of corporate debtor. When the CD's assets have been totally liquidated, the liquidator must apply to the AA for the CD to be dissolved under Section 54 of the Code. Early dissolutions can be requested under Regulation 14 of the Liquidation Regulation at any time after the preliminary report has been prepared if the liquidator believes there are insufficient realizable assets to cover the liquidation cost and no further investigation into CD's affairs is required. Once the order of dissolution has been issued, it must be launched with the authority where the CD is registered. Next, fast track CIRP. The provision for fast track CIRP are laid under Part 2, Chapter 4 of the Code, and the application for fast track CIRP could be filed by the creditors or corporate debtors as the case may be. And these are the steps of the fast track CIRP. First, appointment of resolution professional. An insolvency professional can be appointed as a resolution professional only if he is not the related party to the concerned corporate debtor. Public announcement. An appointment insolvency professional as interim resolution professional is bound to make a public announcement of his appointment but not later than 3 days from such an appointment. Next, submission and verification of claims. The operational creditor and financial creditor have to submit their claims with proof in a prescribed manner within the time period of 10 days to the interim resolution professional, along with the supplementary documents and classification. After receiving the claims, the interim resolution professional has to verify the same within 7 days from the end date of receipt of claims and has to publish the list of the creditors. Next, formation of COC. The interim resolution professional has to form a COC. Next, meeting of COC. The interim resolution professional is responsible for leading the COC's first meeting at which the interim resolution professional is either appointed as resolution professional or the COC suggests a resolution professional. The meeting must be held within 7 days after the report submission. The meeting notice should be served 1 week prior to the meeting date. Next, appointment of registered value. The resolution professional has to appoint a registered valuer within 7 days from his appointment in order to initiate the liquidation of the concerned corporate debtor. Next, drafting of information memorandum. The resolution professional has to draft the memorandum of information in electronic form and should have conveyance to all the members of the COC. Next, formation of resolution plan. It is drafted by resolution applicant as to be in accordance with the need of committee of creditors and should consist of all the measures needed to implement. Next, approval of the resolution plan. The plan submitted by the resolution applicant is shortlisted by the resolution professional and the appropriate resolution plan is sent to the COC seeking their approval. Next, submission of approval plan to AE. After the resolution plan has been approved, it is delivered to the adjudicating body with the necessary clarification. The adjudicating authority may issue an order approving or rejecting the resolution plan after receiving it. The fast track method is a well designed system that evades the difficult procedure for small businesses, making it easier to do business. The goal is to encourage and create corporate culture in order to help Indian economic growth. Next is voluntary liquidation of corporate persons. Voluntary liquidation refers to resolution of a solvent corporate debtor with the approval of shareholders of the company. It is a liquidation process with minimum intervention of court. Next, reason for voluntary liquidation. When a corporate entity is incorporated for a particular purpose and such purpose has been accomplished, when the article of a corporate entity provides for the happening of certain events and such events have been occurred, when the corporate entity is unable to carry on the business. Next, law relating to voluntary liquidation. A corporate person who intends to liquidate itself voluntarily and has not committed any default may initiate voluntary liquidation proceedings as per Section 59 of IBC 2016, read with IBBI Voluntary Liquidation Process Regulation 2017. That's all. Thank you.